Is it showing live? I believe we are. Okay. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of Evictions and Knowing Your Rights. My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Rachel Gutierrez. Also, on behalf of our presenting partner with Lone Star Legal Aid, we have Mr. Eric Quatler, who's going to be presenting and providing the information for you today. I know it says Kimberly DK, but disregard that part there. Mr. Eric is going to be presenting information for you all today about evictions and knowing what your rights are, what landlords can and cannot do, what the eviction process is, how to basically fight for your rights and to advocate for yourself. So we hope that you all get the information that you all came to hear about today, and knowing about different services that are available. But also included in our partnership, we have the Earl Carl Institute, the Houston Bar Association, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up A Month of Service. And basically, A Month of Service is the collaboration of all of our organizations. We come together on a monthly basis and offer a variety of different workshops, resources, and information to the community relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We know that there are a lot of underserved communities out there that need information, that need access to available resources, and they don't know sometimes where to go to get that help that they need. So we know that a lot of people are still experiencing financial difficulty since the time of COVID, with all of the different storms and hurricanes and things like that that have been coming our way. There have been a lot of issues with renters, and landlords, and people just not certain about what their rights are and what is it that they can do, again, to help with preserving their homestead, and basically knowing what your rights are. So again, we want to thank you guys for joining us this afternoon. This is your opportunity to get access to information. We have a professional in the legal field, an expert in evictions, that's here to provide this information for you. So you have the opportunity to ask questions. We ask that you try to keep your questions to be as general as you possibly can. Feel free to type those into the chat. Please keep in mind that we are broadcasting live on our YouTube channel, and shared on our Facebook and other social media platforms. So please make sure that you try to keep your questions general to try to, not divulge any personal detail information about yourself or your particular situation, for everybody to kind of actually, have access to it and to get out there. So we want to try to protect your privacy as much as we possibly can. So if you are watching on Facebook or on YouTube, please feel free to type your question into the comment section, and we'll make sure that your question is read aloud for the presenter to address for you there. Also, keep in mind that the information that we do provide throughout all of our workshops is for educational purposes only. It is not to be considered legal advice. However, we do encourage you to reach out to our legal service partners, like Lone Star Legal Aid, if you do find yourselves in need of any civil legal assistance. And then Eric is going to kind of go into a little bit more detail about other services that are available at Lone Star Legal Aid, and what they do and other things that they can do for you. So with that being said, we're going to go right on into our introductions and into our presentation. So again, thank you all for joining us this afternoon. Rachel, would you like to go ahead and introduce yourself?
Yes, thank you, Nia. Good afternoon, everyone. My name is Rachel Gutierrez. I am a community outreach coordinator for the City of Houston Department of Neighborhoods, Office of Neighborhood Engagement. On behalf of our Mayor Whitmire and our Director Herbert Sims, we thank you for tuning in to our A Month of Service workshops. We continue, as Nia said, to provide this information to you all because we know that it is definitely needed. And, we always think about reaching out for help whenever there is a disaster or something negative happening in our life. But this information is also for prevention and for education and for preparation, just in case something does happen, or just to know so that you can share the information amongst someone that you may know in your inner circle or those around you, whether it's at church, your place of worship, your community centers, your gyms, wherever you visit, and you may overhear somebody that's in their time of need. So we definitely appreciate you all for being those advocates for those individuals, not just for yourself, but for others. So please continue on participating and sharing in our workshops, but also invite them to join. Obviously, the workshops are for free. If there's currently a workshop that we do not have and you're wanting to possibly receive education on that certain issue, feel free to email myself or Nia, and we're more than happy to work on that to see if we can be able to put that on for you. We're open to suggestions, any feedback. So we do, again, appreciate that. And hopefully, also, we're going to start doing more in-person workshops. So that's in the works. So hopefully that we'll be able to reach even more individuals. But we thank you for being here this afternoon.
All right. Eric Quatler, you want to go ahead and introduce yourselves and go right on into your presentation.
Sure. Hi, I'm Eric Butler. I'm the managing attorney of the Eviction Right to Counsel unit at Lone Star Legal Aid. I apologize I can't have my video on today, but I promise I'm a real person. So I want to talk to you today about evictions, and by all means do ask questions if you have them. I will reiterate that they need to be kept general. I can't give you any advice on your specific situation with specific facts, and you do want to keep it private. And if you do, after the presentation, feel that you want some more information about something that's going on in your particular in your life or your particular case, you're welcome to give us a call and see if we can help. Okay, so evictions. First, I want to talk about us. Lone Star Legal Aid is a nonprofit law firm. We're a legal aid law firm, as is in the name, which means we represent people for free. That representation is limited based on a number of factors, including income and others. We can't represent everyone. We only have so many resources and we have certain cutoffs, but we do our best to try and give assistance to as many people as we can. And there is no way we can give you assistance if you don't call. So I would encourage you not to assume that you don't qualify. You may, and you definitely won't qualify if you don't contact us. Okay. Let's talk about leases. All right, there's a common misconception that if you have a lease, it has to be in writing. That is not the case. You may have an oral lease with a landlord. The requirements for something to be a lease are simply that it's an agreement. And it doesn't necessarily have to involve rent, though almost all leases do. It just governs the rules regarding the use and occupancy of a dwelling. The lease does have to be in writing if it's for longer than a year. However, if it is not for a specific term, for instance, you just are renting a place ongoing, then that can be oral. You can ask the landlord for a copy of your written lease if you do have a written lease, and they do have to provide you with one within 3 days. So that can be very useful because a lot of people don't know exactly what their lease says, and you can ask your landlord for a copy and review it yourself. If you never received one, I do encourage you to ask for a copy. Okay, so written leases are often very long. And it's important to understand that with the vast majority of written residential leases, there is very little bargaining power for the tenant. basically the landlord says, this is what you're going to sign if you want to live here, and you sign it or you don't. So there's a lot of sort of boilerplate legalese on a lease that is not going to affect your everyday life. And so it's important to look for the most important things that are going to affect you. So what are those things? The monthly rent, right? Not just how much it is, but when and where to make payments. When is it due? Is there a grace period? If you are late, what are the fees? How payments are applied. For instance, if you're late and you pay your rent, does that rent get applied first to your late fees from previous tardy payments, or does it automatically just go to rent? Because there are different implications for non-payment of rent and non-payment of late fees. The initial lease term, you need to figure out exactly how long this lease is for. If it's month to month, meaning that basically there is no term, or they just say they might say month to month, then you need to figure out exactly how that works, because it's a little different from, say, a year-long lease or a 6-month lease. Community rules and policies. These will usually be incorporated separately. Basically, the lease will say, we are incorporating the community rules that are attached to this lease, and then they'll give you a document saying these are the rules. The rules are stuff like, don't make noise outside after 9. You can't have lawn chairs in the street, whatever it is. And so if those are attached, you need to make sure you read those rules, because the landlord can be kind of nitpicky with those things. There may be what we call addendums. So basically additions to the lease. If you are in housing, there will definitely be an addendum that governs your voucher. Okay. There are also other addendums like bed bugs and things like that. It can get overwhelming. Some of these leases get up to 30, 40, 50 pages with all this nonsense. Acts of default. So you can't evict it unless you default on your contract. So it's good to know how that happens. The obvious way is to not pay your rent. The vast majority of evictions, and we're talking over 90%, are for non-payment of rent. So most people who get into trouble with evictions, they haven't paid their rent. They may have had a good reason, right? Certainly an understandable reason, that they had a surprise expense, or they had a change in income, something that happened that wasn't their fault, but they just didn't have enough money to pay the rent that month. And so even if you do have one of those good reasons, usually they're not good enough under the law. And we'll talk about that later. Material breaches. So if you do something that very seriously interferes with the landlord's ability to run his complex, then you will definitely face the possibility of an eviction. It doesn't have to be that grave, though. For instance, you may have, if you have an unauthorized occupant in the unit, that may be enough. If you have unauthorized pets, if you are constantly leaving trash all over the place, things like that. Also, early termination or holding over are important to talk about. They're kind of two sides of the same coin. Early termination basically means that you are saying, I'm out, and not finishing your lease. And most people think this is breaking the lease. And sometimes the lease will tell you exactly what the implications of that are. For instance, the lease may say, we'll let you out of your lease with a flat payment of, say, 1 or 2 months rent, right? So if you pay them X amount, then they'll just let you go. Sometimes they won't. So it's important to read that part of the lease. Also, what happens if you stay beyond the term of the lease? There are specific rules about how you end the term of a lease. So, and that's the notice of lease renewal or non-renewal. Basically, you and the landlord are forced to give X number of days notice that you will not be renewing the lease. If you don't, then the lease does not terminate. So usually it's either 30 or 60 days. And so if the lease doesn't terminate and you stay, sometimes the lease will say, for instance, that your rent will go up if you stay beyond the term of the lease. So it's important to understand the implications of doing that. Under timelines, we also have the notice to vacate, and we'll talk about notices to vacate a little bit later. And notices of default, basically letting you know that you have done something that is a default, but not rising to the level of a threat of eviction yet. Okay. Leases are not meant to be eternal, right? It's understandable that both parties should have the right to terminate the lease at the end. Landlords are not meant to be bound to let you live there forever, even if you are paying rent. Similarly, a landlord can't force you to live there past the date that you agreed to live there. So this is completely understandable. And as I was talking about before, in order to terminate the lease and say, you know what, this isn't working, we're not going to do this anymore, even if they don't have to have a good reason, as long as they just say it, then there is going to have to be a notice of termination. There are a couple of special circumstances in which a landlord might have to renew your lease. But you know, one of them is certain kind of subsidy programs. Another one is if they have broken certain rules, but those are relatively rare. In general, you should assume that you cannot make your landlord renew your lease unless you've been told otherwise by the housing authority or another trustworthy authority, not the landlord. For early termination, if there is not a flat fee, then you need to understand that if you leave, then the landlord, if they can't rent the place out immediately, can keep charging you rent. So if you leave 3 months into your 6-month lease and the landlord puts it on the market, but just can't, no one's interested and can't, and they can't relet the place, then you're going to be responsible for rent until they do. Now they have to make a good faith effort to relet the premises, right? They have to put it on the website, say, you know, we have a 1-bedroom available. Anyone who wants it can make an application, etc. But that doesn't mean that they're going to find someone right away. So it's important to understand the implications of doing that. When can you freely early terminate? Family violence. So in certain cases, if in cases of family violence, that means both, it doesn't mean just marital violence, it means any kind of domestic violence, dating violence, it could be violence between family members, you know, there may be either an abusive child or an abuse, you know, or younger generation or abusive parent. Those are all cases of family violence. If that arises, regardless of whether the abuser is and the victim are living in the same unit, then there may be a right to terminate the lease early and leave. Do not just do this, though. There are rules, and I do recommend that you try and seek legal assistance if you want to terminate early due to family violence. Same thing with sex offenses or stalking. Tenant's death, they can't charge a dead person like rent, but they can charge the estate anything that's not paid. So just because someone dies doesn't mean that their past rent debt goes away. That's a general premise of people dying. There are also military service applications, implications. If the tenant is deployed, then it's possible that the landlord will be obligated to let them out of the lease without penalty. Casualty loss. Now, this is one that is really important right now. So when we talk about casualty loss, we mean a significant damage to the premises by an act of God, essentially. So, or in legal terms, we call it force majeure, and sound exactly what it sounds like, major force, right? So things like, say, a hurricane or a derecho or other extreme weather events. So what are the implications? If premises is made totally unusable and the loss is not the tenant's fault, then the tenant has the right to terminate the lease and leave with 7 days notice. Similarly, the landlord does, because the tenant can't make them let them live in a place that's not safe. If the premises are made partially unusable and the loss is not result of tenant's fault or negligence, then the tenant may be able to petition a court for a reduction in rent. You can also always negotiate with the landlord for that kind of thing. If the unit is still partially usable, though, the landlord cannot just kick you out. The thing that we're seeing here is landlords attempting to make tenants whose units were made rendered totally unusable continue to pay rent. They can't do that. All you have to do is send something in writing saying, we're out. See you later. This place is unusable. We're leaving. They cannot threaten you. Well, they can threaten you with continuing to charge you rent, but they can't legally do it, which is a good time to explain the very nature of laws. So my dad has a saying, locks are meant to keep honest people out. Someone really wants to get in, they'll break the lock. The same is true of laws. Laws are simply sets of consequences to actions, right? They're not force fields. It's not that a law says a landlord can't do this. It says that a landlord can't do this without incurring certain consequences. So never assume that a law is going to completely insulate you from bad actions. All it does is say you have rights to force the opposing party to do certain things. A good example would be a protective order for domestic violence. A protective order is a document saying that if the abuser comes within X number of feet of wherever it is, or does a certain thing, then they'll go to jail. It doesn't establish a perimeter around the house that they can't enter through. And the cops aren't around all the time. So we're going to talk about rights here and what landlords can and can't do, but it's important to understand that your rights are simply consequences to the landlord violating them. The same is true here. The landlord is not legally allowed to make you stay if your apartment or home is destroyed by a hurricane or make you continue to pay rent. That doesn't mean they won't try. Okay, so termination of the lease due to a breach. This is where evictions come in. A breach of the lease is any violation of the lease terms. This is when we're talking about default. So the most common ways tenants default on leases: failure to pay rent on time, repeated violation of community policies. Usually you're not, unless there's some ulterior motive, the landlord is probably not going to file eviction on you because you had a party one time that was a nuisance, right? It's going to be you are a continued problem that is disrupting life for the other tenants. Unauthorized tenants, talked about that. Criminal activity by tenant, occupants, or guests. That's right, not just the tenant, but anyone you allow on the premises. If they commit a crime, then that can be imputed to you. And holding over, meaning that the landlord did give you a notice that the lease is going to terminate on time and you just didn't leave. If there's a breach, the landlord must provide a proper written notice before filing an eviction. And we're going to talk about that notice to vacate. Withholding rent. Okay. The iron law of landlord-tenant law, it's repetitive. The iron rule of landlord-tenant relationships is pay your rent. There is no such thing as a rent strike in Texas. A rent strike is otherwise known as an eviction. You cannot withhold rent, even if the landlord is not doing their job. There is one very, very arcane provision that allows it under certain circumstances. I have never in my life seen anyone do it right, and it is very limited. So I'm not even going to mention it. Pay your rent. There are several consequences to not paying your rent, one of which is obviously eviction. But also, there are other rights that you can assert against your landlord that go away if you are behind on your rent. Those rights include forcing a landlord to make repairs. So if the landlord is not making repairs, and you decide you're not going to pay your rent because the landlord's not making repairs, you lose the ability to legally make them make those repairs. So pay your rent no matter how mad you are. So not paying your rent generally is going to get you in evictable trouble. However, there's an exception. If the landlord refuses to take full and timely tendered rent. Basically, if you go to, let's say you pay through at the office, you go to the office with your money order and they say, no, we're not taking your rent this month. If the money order covers everything you owe, is on time, in that case, they are not allowed to evict you. Again, though, that doesn't mean they won't try. There's a reason I specifically said full and timely tendered rent. Landlords are not obligated to take partial payments. Landlords are not obligated to take late payments. If your rent is 1 day late, the landlord can say, I'm not taking it, I'm evicting you instead, even if you have the rent plus the late fee. That's the law. Whether it should be is a different conversation. Another way that they might do it is if you pay through a rent portal and suddenly you lose access to the rent portal. If you try to access the rent portal on time and pay your full rent, then you can't, then they can't evict you for not paying it. So what do you do if this happens? Make sure you're in the right. So what do you need to do to make sure you're in the right? Make sure you actually had enough money, right? That you're paying the full rent. Make sure you were actually paying it on time and that you weren't late. Make sure that you were actually trying to pay it in a way that is identified as allowed in the lease. So it's important to make a distinction there between that and a way that you've been allowed to pay in the past. It is best to follow the lease when possible. If the landlord agrees to take rent in a different way, then you should ask for a written alteration to the lease saying that that's the case, because they can withdraw that and it's going to be difficult to prove in court later that you should have been allowed to pay the way you'd been paying before. Documentation is key. So if they refuse to take your rent, then say you want that in writing. Tell them that you want to document that in writing. If they're not going to take your rent, they need to tell you why. If they refuse, then do your best to memorialize this in any way possible. One way would be email, right? They may not return your email, but if you send an email saying, I tried to pay my rent today, you refused it, that at least will later prove that you said at the time you were trying to pay your rent. It's a good thing. Don't spend the money. If they refuse rent, keep it, if at all possible. Now, I know we all have lots of expenses, and suddenly not having spent $1,200 that month on rent makes that $1,200 look really good for paying down some credit card debt or whatever else it is, or fixing your car. But if you want to avoid eviction in the long run, you're going to have to keep that money available for rent. Otherwise, they're just going to evict you later for not paying. Continue to offer rent in full and on time. So you don't have to do it every day, but do it when it's due. So if they refuse to take your rent and they don't do anything about it, and then the next month comes around, you go back down there with both months and say, I'm trying to pay it again. If they refuse it again, just keep going. It's also recommended to contact an attorney if this is going on, because usually if they are refusing to take your rent, an eviction is coming. Okay. So first, I want to talk about what an eviction actually is. When people think about the word eviction, they think of someone being removed from their home forcibly by the cops, right? That's not an eviction. That's the last stage of an eviction. An eviction is a lawsuit. It is a lawsuit filed by the landlord against the tenant, saying they have breached a contract. There are certain things you have to do before you can file that lawsuit. And as in any other lawsuit, you have to be served by the constable. Like, for instance, if you were being sued over a automobile accident, right? Lots of us have had that happen where the constable or a private process server, in this case, it has to be the constable, but someone comes asking, are you X person? And you say, yes, you've been served and had you some documents. It's like that. And then the lawsuit is filed and you have to go to court where they have to win their lawsuit in order to remove you. After that, then comes the procedure by which they can actually remove a tenant from the unit. So when we talk about eviction, this is fundamentally a lawsuit. And I'm going to go through the steps with you. The first one, before they can file the lawsuit at all, is the notice to vacate. So a notice to vacate is supposed to tell you you have breached the lease. As a result, you don't get to live here anymore. Move out in X number of days, or we will have the right to file an eviction. Because that's pretty important, right? It's pretty important that you are told and know that your lease has been terminated and you have to move. The law requires that the notice to vacate be delivered in one of a few very specific ways. These ways are designed to make sure that the actual tenant actually receives the notice to vacate. So, what are the proper delivery options? Hand delivery is always a proper delivery option. What does hand delivery mean? It means actually taking the notice to vacate and handing it to an occupant or tenant in the of the apartment over the age of 16. Can't hand it to your 13-year-old kid. They have to hand it to they can't hand it to your brother who's visiting. They have to hand it to an occupant or tenant who's over the age of 16. Mail is fine. So it can be regular mail, just to put it in an envelope, put a stamp on it, and send it in the mail. That's fine. It can also be certified mail. CMRR means certified mail return receipt request. The other way they can do it is posting it to the inside of the front main entry door. So that means they open the front door, slap it on the back of it with some tape, and then close the door and leave. It does not mean shoving it through the door jamb. It does not mean sliding it under the door. It does not mean posting it on the outside of the door. It has to be posted on the inside of the main entry door if they leave it. There is an alternative if the landlord cannot or should not enter the premises, should not being, for instance, they know that there's a large dog who makes it dangerous for them to open the door. They can put the notice in an envelope affixed to the outside of the front door securely. And it has to say, read me, or some equivalent. Basically, it has to express in large, bold letters that it's urgent. The landlord also has to mail it. So they have to do both if they want to leave it on the outside of your door. If you do get a notice to vacate on the outside of your door, take a picture of it before you take it down and make sure you keep that copy. Sorry, it looks like we have a question I didn't see 23 minutes ago. Sorry. How many days after non-payment of rent can an eviction notice be made, or is it by lease? It's by lease, but generally, so the lease may sometimes says the rent is due, say, on the 1st, and there's no grace period, right? Okay, then they can give you a notice to vacate on the 2nd. It may say it is due on the 1st, but there's a 3-day grace period, in which case they could not give you a notice to vacate until after that grace period is over. Okay. So there's a federal law from 2020 called the CARES Act. It did a lot of things. It was the first major COVID Recovery Act. Almost all of it is gone. It just expired. But there's one provision that is relevant to us that remains. It says that certain covered properties, that doesn't mean as in they have an awning, it means that their property is covered by the law, are required to give a 30-day notice to vacate. So what are covered properties? Property participates in a covered housing program under VAWA. The bullets 1 and 2 here are essentially the same thing. If they take federal money, then they're covered. And so if there is one tenant in that complex who gets a voucher, then everybody's covered by the CARES Act. Certainly, if it's a project-based Section 8, meaning that the voucher, you have a voucher because you live there, not a voucher that you can take anywhere. Public housing or tax credit property, things like that, you may or may not know whether you live in one of these properties. Then in that case, the property is covered and they have to give you a 30-day notice to vacate. The other one is if they had a federally backed mortgage. So a lot of mortgages are backed by Fannie Mae or Freddie Mac or another corporate government corporation, essentially. And that's both single-family home mortgages and multifamily mortgages. So it's possible that the entire apartment complex was bought using a federally backed mortgage. And basically, unless you have a lawyer, it's going to be very difficult to figure out whether that's the case, which is why you should call us if you're getting evicted. So if one of these applies to your complex, then you may be entitled to a 30-day notice instead of a 3-day notice. As it says, for large properties, some databases are available. None of them is reliably current. Okay. So evictions. Now we're on to the actual lawsuit. So they've given you a notice to vacate, and the number of days in the notice to vacate has expired. They now have the right to file a lawsuit, namely an eviction lawsuit. The technical legal name for an eviction lawsuit is forcible detainer. So basically, that means what it sounds like. You are forcibly detaining possession of the premises against the will of the owner when they have the superior right. So what is at issue in an eviction lawsuit? There is only one thing at issue in an eviction lawsuit. Who has the superior right to possess the property, the landlord or the tenant? If the tenant has in fact breached the lease and defaulted, then, and the landlord has given them notice and they have stayed, then the landlord likely has the superior right to possess the property. However, if one of those things isn't true, then the tenant likely has the superior right to possess the property. So, what does a landlord have to prove? Right. In America, when you file a lawsuit, in almost all cases, it's your job to prove that you're right. Right. You don't file a lawsuit against someone saying that you hit my car and then say, now you have to prove you didn't. Right. That's not how it works. So that's the same as evictions. At least in theory, the landlord is supposed to prove their case. So what do they need to prove? One, they need to prove that they're the owner or that they have the right to represent the owner. Someone who is, I can't just come in and say, I'm going to sue you for possession of your place when I'm just a stranger, right? I'm not someone who owns the place. That doesn't make any sense. They need to prove that there was a breach, right? Or that you stayed over a proper termination, the holder. They need to prove that they gave you proper notice to vacate. And they need to prove that the tenant refused to leave. You cannot evict someone who is no longer occupying property. Now, it's important to understand that occupying doesn't just mean living there. If you leave, but leave all your stuff there and don't turn in the key, then an eviction can be filed against you because you are functionally still occupying the premises with your stuff. So, non-payment of rent. Evictions themselves deal with possession. However, if you're behind on your rent, the landlord can add a lawsuit for the back due rent amounts to the eviction lawsuit. So basically, they come simultaneously. They're different, they're separate, but they come simultaneously. The only thing that a landlord can ask for is rent, not late fees, not utilities, not random charges. All they can ask for is how much rent you owe, period. I'll remind you again, that's all they're allowed to ask for. That doesn't mean that they won't ask for more. They are just supposed to prove that the amount they're asking for is legitimate. You do have the right to request a jury. JP courts, which are the courts that try eviction lawsuits, I can tell you, hate juries. And even if you request one, they will do everything in their power to dissuade you from having a jury trial. However, it is your constitutional right, as long as you request the jury timely, which I think is 3 days before trial in the base eviction, and the fee must be paid, which is, I think, $27. If you cannot afford the jury fee, you can fill out a form saying, I don't have $27. Okay, JP Court, also known as Justice Court. So, Justice Court is not like TV. They don't have most of the rules that a court that you might associate with justice do. They don't have rules of evidence, meaning that you don't have to, that you can basically just put anything in and say, I want you to consider this, judge. They don't have to prove the authenticity, anything like that. If you've heard of hearsay, none of that applies in Justice Court. There are no objections, anything like that. So how do you deal with this? Arrive on time. That's key. Because if you're late and the landlord and the judge calls your case and you're not there, they are very unlikely to reinstate the case. They will tell you get here on time. Sometimes, depending on the court, you will check in with the clerk. Just go up and talk to the clerk and say, I'm here. Sometimes they will call your case and you will have to say, stand up or just raise your hand and say here. The judge may give instructions on how court works beforehand. They may not. At trial, the plaintiff, the landlord, gets to present their case first, and then you get to respond. The judge can ask you questions. The opposing party may or may not be able to ask you questions. But if you have a defense, then you need to bring evidence of that defense. It's not going to work very well for you just to go up and say, nuh-uh. Trial can only be reset by motion of the plaintiff or if both parties agree to the continuance, sort of. The trial will only be guaranteed to be reset if the plaintiff, the landlord, says, I want to reset the trial for later, or if both of you do. However, the court can grant a defendant's request for a continuance. That's usually going to happen if, for instance, the defendant has COVID and can't come to court, right? Or there may be other reasons, but they have to be pretty good reasons. After trial's over, the judge will either issue a judgment saying the landlord won or the tenant won, or they will just dismiss the case. You should always get a copy of the judgment or the order of dismissal. Always be respectful to the judge, court staff, and the opposing party, no matter how much you hate them, because that is a very real possibility that you will hate them, that they will be mean to you, that they will lie, the opposing party at least. You need to stay respectful and not lose your cool. Also, the judge may announce some rules. For instance, no cell phones. Follow the rules. Do not take them lightly, because there are some judges who will take your phone if it goes off and not return it until the next day. Okay. So, an alternative to trial would be a settlement agreement. Basically, the two parties agree to a resolution of the case. Some courts have standard settlement agreements that they encourage people to enter into. Some don't. Usually, what does this look like? Most of the settlements say the tenant will move out by X date. In exchange, the landlord, if they do, the landlord will dismiss the eviction. There may also be a rent payment term, but there may not. If you decide to do this, if you're facing eviction, you decide to do this, completely understandable. But make sure if you decide to do this, that you agree to something that's realistic. Do not agree to something that is not realistic, because you are setting yourself up for failure. And the consequence for most of these settlements for not fulfilling your end of the bargain is that they get everything they want. They get possession, they get back rent, they get court costs, and if they had an attorney, they get all their attorney's fees. So make sure if you do one of these that, one, you understand what the terms of the settlement are, and two, you truly believe you can abide by them. Settlement has to be generally in writing, signed by both parties. Those are the requirements. It's better to follow them with the court. The court often just means handing it to the clerk, who will make copies for you and then keep it. The settlement agreement may involve parties giving up rights. For instance, you could theoretically give up your right to appeal your eviction in a settlement agreement. I strongly discourage that, but it is possible. Okay, so let's say you lose. Most tenants do. That's just the reality of it, especially if they don't have an attorney. Within 5 days of the court date, if you do not have a lot of money, request an inability to afford court costs and fees form, we shorthanded to IFP, from the clerk. They will also call it a statement of inability to pay the appeal bond, because in order to appeal, the judge will set an amount that you have to pay to the court. You can get out of that, though, by saying, I don't have enough money. Our court system is designed to give access to everyone, regardless of whether they can pay for it. You should not have to pay money you don't have or be denied access to the courts because you don't have enough money to access them. As a result, the judge will set this appeal bond, but if you don't have enough, you can tell the court, I don't have enough. I want to appeal, but I don't have enough money, and the form will ask you to prove it. So you'll put on your resources, both your income and your assets, and then you'll put on your expenses and show that you don't have enough money to pay the appeal bond. If you're being evicted for non-payment of rent, almost always you will be qualified for an statement of inability to pay. Within 5 days of filing the form, you do have to pay the court, but it's different. So if you file one of these statements, your appeal goes through, period. You will have an appeal at the next court, period. However, if you want to stay in the premises during that appeal, you do have to pay the court 1 month's rent. That is not a fee. It essentially is escrow. The court keeps the money, and then at the end of the case, whoever wins gets it. If you are no longer in the premises, you do not have to pay this. So if you leave, but you still want to get the eviction off your record, you don't have to pay 1 month's rent to the registry. But if you want to stay, you do. Basically, you don't have to pay to play, but you have to pay to stay. So what happens if you file the IFP? The case will be transferred to the next court, which is the county civil court at law, and assigned to a court. Almost all eviction cases right now are being assigned to one judge. So it will almost always be the same court. You will receive paperwork from the court in the mail and possibly from opposing party. So check your mail. If you filed the IFP form to appeal, you do not need to file a separate answer or pay an additional filing fee with the county court of law. However, if you did not, then you are going to need to file an answer with the court and pay the filing fee. Additionally, if you file with the form, if you say, I'm too poor to pay the bond, and you file, and then you pay your first month's rent into the court registry, you will also have to pay your rent as it comes due into the registry of the county court. Usually the first of the month, you have a 5-day grace period to pay it. If you don't, the landlord can file a motion to get you out of the place. They may not, but they can. But even if that happens, your case will still go to trial. Okay, county court of law. The case is heard what we call de novo from the beginning, meaning that they don't care what happened at justice court. And they will get mad if you try and tell them. They will get mad if the landlord tries to tell them. They don't want to hear about it. County courts use formal rules of procedure and evidence. So this is much more like court that you may have seen on TV. Now, it's not as bombastic and dramatic, but it's more similar. There are objections. There are, they have to prove their evidence, things like that. You have to pay attention during trial, because if you don't, you're going to miss the things that they try and use as evidence. And you will need to prove that you will need to contradict the evidence that they provide. The landlord has to prove up their case with testimony and evidence. It can't just be someone saying, oh yeah, they were behind on their rent and so we evicted them. That ain't going to cut it at county court of law. They have to show that you were behind on your rent with a ledger. And they have to show that they provided a notice to vacate. They have to show that they own the place, etc. If you lose again, here you can appeal again, but it's much, much more difficult. The appeal bond will be very high. It is possible to get it lowered, but you can't do it without an attorney. I can tell you that. And I can also tell you that most attorneys are not going to take evictions up on appeal this way, because in most cases, there are not sufficient grounds for appeal. The cost of appeal from county court is usually 10 times the monthly rent. Like I said, it's very high. If you have not made your monthly payments into the registry of the court as required, because you filed an appeal with the IFP form, then it's possible the court will grant an immediate writ of possession. So what's a writ of possession? A writ of possession is a document from the court instructing the constable to remove the tenant from the premises. It is the last step of an eviction. It is the thing you want to avoid the most. So if you don't appeal, a writ of possession will be issued against you by the justice court. If you lose in county court and don't appeal, then a writ of possession will be issued against you by the county court. And at that point, the constable will come within, depends on the precinct, how backed up they are. It's not going to be right away, but it's sometimes within a few days. They'll give you a 24-hour notice that they're going to come back the next day, and come back the next day and remove you and all of your belongings and put them on the curb. Okay. There are some special cases where some of the rules are different. Public housing and subsidized housing. So subsidized housing includes vouchers. If you have a voucher, then the landlord will have signed a contract with the housing authority saying that we are going to accept X amount from the housing authority every month in satisfaction of whatever % of the rent is covered. We call this the HAP contract, the Housing Assistance Payment Contract. In that contract, there are additional requirements for termination of the lease. In some kinds of subsidized housing, there are also prohibitions on terminating the lease for anything but very good cause. So if you receive a subsidy, it is important to know that you may have additional rights. And you can contact the housing authority that governs your subsidy and ask them about those rights, or you can contact an attorney if you think you might face eviction, or if you are facing eviction. If you have a voucher or a different subsidy that lowers your rent, basically most of these subsidies say we will pay a percentage of your rent and you will be responsible for the rest. So let's say your rent is $1,000 and you have a 90% voucher, then you pay $100 a month every month, and the housing authority will pay $900. If you get evicted and you have to pay rent into the registry, like we talked about for appeals, then you only have to pay $100 into the registry every month, not the full 1,000. If the court screws up and tries to tell you that you have to pay the full amount of rent, you need to contact the court within 5 days and say, no, I have a subsidy. I need to file a contest on this. Okay, other things that might happen when the lease is breached. Technically, these might happen even without a breach, but they especially happen when a lease is breached. Let's talk about lockouts. I love lockout cases because we always win. Why do we always win? Because in Texas, if you lock a tenant out, you have to provide them with a new key 24/7. You have to tell them where to get a new key, what number to call for a new key. But again, have to just means if you don't, there are consequences. It does not mean that all landlords who lock their tenants out do it. In fact, I have never seen a landlord follow the correct procedure in its entirety for a lockout. Most landlords who lock tenants out are bullies who think that they are above the law. They are correct if no one intervenes. However, there are consequences to illegally locking someone out. If you are illegally locked out, then you should immediately call an attorney and immediately contact the person to whom you pay rent, whether it's the leasing office or the rent man or whoever it is, and say, I want a new key to my place. Now, in 2024, lockouts can look a little different from the traditional lockout, right? Normally, when you think about a lockout, you think about them changing your keyed lock. Well, a lot of people don't have keyed locks anymore, right? They have combination locks. And so a lockout could be that they change the combination on your lock, right? The digital lock. Or there's something called a key block. A key block is a rubber device that will surround a doorknob, and it has a lock on it. So basically, it surrounds the doorknob and it prevents you from turning the knob. So they haven't changed the lock. They've just stopped you from opening the door. All of these are still lockouts. They count just as much. So it's important to remember, if you get locked out, ask for a key. If they won't give you a key, call an attorney. I can tell you that most of the lockout situations that I faced are solved with a call by me. I call them and say, you're going to provide a new key to my tenant, to my client. And guess what they do? Because they know. They know they're supposed to. They just don't, because most people don't invoke that right. They don't know that they have the right to a new key. Utility shutoffs. Basically, we're talking about when a landlord cuts out your power and your water. They're never allowed to cut out your water, period, unless they're doing some sort of maintenance that requires it, which is fine, right? That happens. But they can't do it because you haven't paid your utilities or your rent. They can potentially cut off your electricity, but only if it's an all bills paid complex, meaning that you actually pay your electricity bill to the landlord, not to Reliant or whoever else. And it's in the lease that they can, in bold. So it's another reason you should read your lease. If you have an oral lease, they cannot cut off your utilities. And again, by cannot, I mean if they do, there are legal consequences, not that they are physically barred from doing it. Okay, so if you do have an illegal lockout or utility cutoff, what do? You ask for, in the case of a lockout, a writ of reentry. In the case of a utility shutoff, a writ of restoration. You can go down to your local justice court. Justice courts are by precinct. There are 8 precincts in Harris County. You can go on the constable's website, because the constable precincts are the same as the justice court precincts. And there are 2 courts in each precinct. You can file in either of them. They are designed to be geographically dispersed, so you have a neighborhood court. However, it may still be quite some distance from your home. You can go and say, my landlord locked me out. I need to file a lawsuit, and they will give you the form for a writ of reentry. You can go and say, my landlord cut off my power. I need to file a lawsuit to get it back. They will give you a form for a writ of restoration. There is a cost, but again, if you can't afford the cost, you could file an IFP. Same form, basically, saying, I can't afford the filing. It's not as expensive. It's not that expensive. It's not like an appeal bond, which can be like twice the monthly rent. We're talking like $50, I think. But still, that doesn't mean you can afford $50, right? If you're being locked out, guess what? You probably don't have very much money. So it's better to get an attorney involved. Though. Call us if you have been locked out, and they won't give you a key, because we can't have people on the street for nothing. Okay. Already talked about some of this, but what's the process? You file for the writ of restoration, or the writ of reentry for a lockout. Once you file it, you will schedule a hearing with the judge. The landlord does not have to be there, but they can. You don't have to tell the landlord about the hearing, but you can. The court may tell you it's generally our policy that we have the landlord there, That's fine, except they can't actually make you have the landlord there. You can insist that you are living in your car, you are locked out of your place, and you need a hearing now. It may or may not work. The judges aren't always nice, but it will be on the courts. It will be on the court to try and contact the landlord to get him there. Usually, if the landlord still won't pick up their phone, they'll have the hearing. Once you go to the hearing, you say, they locked me out. I asked for a key and they won't give me one. And if the judge agrees, then they will issue this writ, which is like a writ of possession in that it's an order to the constable to do something. In this case, it's an order to the constable to go down to your complex or your house and tell the landlord to give you a key or else. What does or else mean? Well, there may be, if they don't, then there's a further legal process, but one of the possibilities is jail. They will be held in contempt of court if they continue to refuse to give you a key, and the judge does have the opportunity or the ability to throw them in jail until they give you one. That is unlikely to happen. They can also fine them and continue to fine them until they give you one. If this happens, you can also sue them. And you can get a civil penalty of 1 month's rent, whatever your rent is, plus $1,000. Actual damages. So if anything, actual damages are pretty rare in these cases. Court costs and reasonable attorney's fees. If you ask for a key and they refused, the civil penalty is 2 months' rent. You can also ask to terminate the lease immediately. For utility cutoffs, it's functionally the same thing. Same process. You go to court, say, I need my power back on. Case will be set for a hearing. You do not need to serve your landlord. If the judge agrees that utilities were disconnected illegally, then you get a writ of restoration. The constable goes down to your landlord and says, cut the power back on. In this case, actual damages are a thing because if your power gets cut off, you might lose, say, all the food in your fridge, right? In which case, that would be damages you could sue the landlord for. 1 month's rent plus $1,000, reasonable attorney's fees and court costs. If you are behind on your rent or your utilities, then whatever you get in this affirmative lawsuit your arrearage will be subtracted. So if you are behind 1 month's rent of $1,000, then they'll cut $1,000 off your award. Okay, security deposits. Think about security deposits this way. If you're a landlord of a multifamily complex and you have every tenant paying you $1,500 as a security deposit to move in, and you keep every single one giving a bogus reason for not giving it back, a handful of people are going to take you to court. Most of them won't, which means it's a numbers game. That's why so many landlords screw around with security deposits, because most people aren't going to fight. But you should. Why? Because if they illegally retain your security deposit, then you can sue them and get as damages 3 times the amount of what they illegally withheld, plus attorney's fees. They have to give you if you give them forwarding address, they have to give you either the full security deposit back or a written accounting of every single cent they withheld and why. And things that they can't withhold for, most notably, normal wear and tear. So there's stuff that just happens when you live places, right? There's a big difference between the carpet being not in great shape and a giant pee stain from your dog, right? Those are different things. There's a difference between a tiny hole in the wall where you hung up a picture and a place where your stupid brother punched through it, right? Different things. So normal wear and tear is not going to be deductible. They have to have a concrete thing that you did to damage the apartment to do it. Again, they can do it anyway. There are just consequences. And in this case, there are substantial financial consequences. Okay. This first one is really important. Almost all problems have the potential to be solved by a conversation with the landlord. Now, it may not, right? The landlord may be hell-bent on whatever they're going to do, right? But if there's a problem, get ahead of it. If you know that you're going to be behind on rent next month, go talk to the landlord and say, hey, this is what happened, and I need to pay my rent late. My check is coming in on this date. It should have a little extra money I should be able to pay. Can we work it out so I can pay late? Or at least, can I agree to pay the late fees and you will agree that, well, you'll just let me pay the late fees a little bit late and pay my rent a little bit late. That's way better than just, surprise, I'm not paying. Rental assistance is not available the way it used to be, but religious organizations and local area ministries are providing some help. Additionally, if you are a victim of domestic violence, you may be able to get help from domestic violence shelter with rapid relocation. So just think about the resources that might exist. If you are having issues with the condition of the unit, if you've got rats, if you've got mold, if you've got whatever, pay your rent anyway, and then contact someone for help. We're out there. We may not be able to provide help, but we'll at least try and provide you with some advice if you qualify. All right. That's all I got. Thank you for your attention. If you have any questions, I'm willing to answer them.
Okay, thank you, Eric. There was a couple of questions that actually got emailed to me. What's the process or the orders of eviction if they misplace your money orders? If they
So,
misplace your payments?
so you pay, the idea is that the tenant paid and the landlord just lost their money.
Yeah.
I mean,
Okay.
this is why you should always get a receipt when you pay your rent. So, because then if they try and evict you, you go before the judge and say, Judge, I have receipts. I paid my rent. It's not my fault that they lost it. But the process is no different from if you hadn't paid your rent. It's still a non-payment rent eviction.
Okay. I am a sublease and could not make it to court. What am I to do?
So regardless of whether you're a sublease, if you don't make it to court, then you will, if the landlord did go, then you're probably going to have a default judgment, meaning that the landlord just got what they wanted because you didn't show up. You can appeal that just like any other loss. So if you couldn't make it to court, you should appeal the judgment.
Okay. I've appealed an eviction and recently met with the owners. I have always dealt with the managers here. The owners said things in court that are not true. They retaliated and told my car. I live in an RV park with only part of the utilities working. Okay, let me read the rest of this paragraph and then I'll paraphrase this question because this one's very long. But Judge Adams is actually here. And you had a question or a comment, Judge Adams?
Good afternoon. I have a question.
Afternoon.
Thank you for today's presentation. Question is, the other day we had a question from a tenant and you called, no, I can't give legal advice from the bench or any type of advice. But since borough happened, right? And say that the landlord property was damaged really badly, like damaged really bad, ceiling caved in, and the tenant can no longer live there. I heard the presenter said that they still have to pay rent anyway, but in the midst of disaster, are there any rules that's out there based on if a disaster occurs and the tenant has to move concerning rent payment? And if so, does the landlord still have the right to evict the tenant even though the house is inhabitable or the property is inhabitable?
Yeah, Your Honor, thanks for asking. I addressed it. Maybe I misspoke, but the property code explicitly says that if a unit is entirely unlivable, the tenant has the absolute right to terminate the lease with 7 days notice. So no, the landlord cannot force them to continue paying rent. They just have to send a letter to the landlord saying, "I'm out. No more. I'm not paying rent for a place I can't live in." And the landlord cannot evict them, cannot continue to charge rent.
So how about if they don't file the notice and they don't know the legal guidance to do the 7-day notice? It's because
Go ahead.
Borough happened.
Yeah, and we tried to do as much outreach as we could on this because of this very specific issue that we saw landlords doing this. There has to be a notice from the defendant legally in order to terminate the lease. However, if the tenant has moved out and no longer has anything there and turned in the keys, then they can certainly present that evidence. But unfortunately, they have to actually notify the landlord that they're leaving because it's out.
Okay, yeah, that makes sense. Unfortunately, this particular tenant is in a hotel and to be forced to go to a hotel because the property was damaged by Borough. And so they was, unfortunately, of course, due to that rule, and they didn't provide the updates, it didn't go in their favor. But I just wanted to know that question because that's come up a lot in these last couple of weeks with tenants around Borough happening and the properties were damaged. So we need to get that out to the, I don't know how to get that because we're faced with that, but they don't know that that rule exists.
Yeah, we went on the news, we did our, if obviously, Your Honor, if you have any ideas about community outreach, we're always willing to listen and try and do it and try and get it done.
Thank you so much. And thank you for the presentation.
Absolutely.
We sorely encourage people to get renters. Renters insurance is fairly cheap. 20-30 bucks a month or something like that to kind of help with preventing something like that when you're having to be displaced or to get that loss of use coverage so that it at least covers some of those expenses for you. So that is something that a lot of tenants also definitely need to consider if they have not done that already. And I know it's easier to kind of say, but it's a little bit more of a peace of mind, especially being in Houston. Storms, floods, all kinds of damage and everything happens, throughout all these kinds of seasons. Plus, you just never know if your neighbor's going to be frying chicken one day and fall asleep. And, you just never know what happens that's going to cause you to have your living arrangements disrupted or something that's beyond your control. So renter's insurance is something that you should definitely also consider. Let's see if there were any other questions here.
Your Honor, was there something else? I see your hand is up.
Oh, took it down. Other than places of worship, have you guys seen any kind of other assistance programs that are out there for some of the folks that haven't been able to get any FEMA or any kind of assistance or anything like that?
I think that we've seen some from like NAM and other ministries of that sort. I can't guarantee, I can't speak for them. I don't want to tell anyone that there's assistance that doesn't exist. But unfortunately, there are no more like local government programs that there used to be for rental assistance. So that, and also there may be problems with the way that assistance is paid. Sometimes the court won't accept a check directly from a church, or it has to be a cashier's check. There can be complications, but there unfortunately are a whole lot of resources.
Why is it that you think most people still, even now, still believe that the notice to vacate is the actual eviction, and they leave without even, giving themselves a fighting chance to stay, as opposed to just moving?
Scary. You get something that says your right to be here has been terminated, leave in 3 days, or we'll evict you. And most people think that when they think eviction, they don't think lawsuit, they think on the curb. So, if you get a notice saying you are behind on your rent, we're terminating your right to be here, be out in 3 days or we'll evict you, they think the constable's coming in less than a week. And so they self-evict. That's the reality of it. That, the notice to vacate can be as mean as it wants to be. It's not professional, but it can start. A lot of them are designed to scare people into self-evicting. And so, yeah, I can't really blame people who aren't familiar with the process of the law for misinterpreting that notice and thinking that if they don't find a way to get themselves and their stuff out to the best of their ability, then the constable's going to come do it for them in a few days.
Interesting. When someone doesn't show up to court for a notice to vacate, how do you prevent a landlord from, I'm sorry, let me rephrase that. What can you do to prevent your landlord from adding on additional charges for things that you don't necessarily owe, for damages and things of that nature, when they go to eviction and then you don't show up for court? Because I've seen people, get collections against them for all kinds of other things that's beyond of what they actually owed for their eviction.
I think I'll let Judge Adams answer this one.
Oh, no, I have a question when you finish. That's a good question.
Oh,
yeah. Ideally, the judge in the court will ask the landlord to establish that what they're asking for is in fact only rent, right? But in a justice court, it's a little different, and every justice court is different. There are 16 justice courts in Harris County, and each one is different based on the judge. And so the answer is nothing, right? The except for appealing. But also it's important to understand that collections is different from a judgment. So it may not be the same amount, it's just different. So if someone gets something put on their credit that they believe is incorrect, then they should contact us, because one of the things we do is consumer law, basically fighting bad debt collections. So yeah, and we're not the only ones.
okay. Judge Adams, you had a question?
Yes, I have a question. So a tenant came to court and they wanted to file a suit against the landlord because in the court, when the eviction docket was held between the plaintiff and the defendant requests for the case to be dismissed in open court. Well, maybe like 60 days later, the tenant noticed that the plaintiff put a judgment on the defendant's record. Is there anything that the defendant can do concerning that matter? Because they have filed a suit, I forgot what they filed to. I don't think it's nothing that I can do, but they asked me, why did the landlord put the judgment on their record when the case was dismissed?
As in they put it on their
a judgment for the amount for the back rent that was owed, but they dismissed the case.
So there's no actual judgment, but they put it on their credit.
No judgment, but they put it on their credit anyway. That
yeah,
was
they should call us.
With yesterday.
Yeah, they should call us or a consumer attorney. There are laws, both Texas and federal, involving credit reporting, and if there's no judgment, they put one and they try to put one on their credit. That's a big deal.
Okay, well, when they come, I think I'm hearing them sometime soon. I just need to know what direction to go into. Because when they did it, we researched it, and fortunately it was dismissed and there was not a judgment placed. But now they're coming to us because they're saying, you put this on my record, and no, we did not. We didn't. So I just wanted to know, so if they call back, what information I can share with my staff, the information only that they can provide to them. So we just tell them just to contact legal aid. Lone Star.
Yeah, I would, yeah. And there are private debt collection defense attorneys, but really this isn't a debt collection defense so much as I mean, it's possible that they need an affirmative suit
Yes.
because of debt reported fair credit violation.
Okay, perfect. Thank you so much.
You bet.
Okay. I think the other question that was in here, this paragraph was way too long, and I believe that they were just kind of ranting about a whole lot of everything that had nothing to do with eviction whatsoever. So yeah, I will send them the note to reach out to you guys if they have any additional questions or what have you. But this is too much information that I really just don't want to repeat on the on this presentation. So yeah. And there aren't any other questions that we have. Appreciate your time and the community. Well, thank you all for joining us this afternoon. We really appreciate you guys for tuning in month after month. If there are some other questions or some additional information that you may need for next time, or if you all know of someone, please pay it forward. Share the information, as Rachel mentioned before, with someone in your circle or someone that you know that may need some assistance and don't know where to go. So it does us no good to keep any of this kind of information to ourselves. We do, that's basically the purpose of why we're here and why we created this collaboration. We're trying to get as much information out to the community as we possibly can. Again, because there's so many people that just don't know. And we want to try to combat that and empower them as much as we possibly can. So thank y'all very much. Thank you, Judge Adams, for tuning in and chiming in with us this afternoon. Thank you, Eric, for taking the time out of your schedule, and we hope you feel better. We thanks to all of the partners in the A Month of Service collaboration. Rachel, is there anything else that you'd like to add? Anything that the city has coming up?
Yes, actually, tomorrow we had a Department of Neighborhoods forum in District K. It's open to the public from 6 to 8 p.m. at the Hiram Clark Multi-Service Center. We will have multiple City of Houston departments providing education to residents. Just because we're in District K doesn't necessarily mean that other districts are not welcome to join, but we're going to be educating residents on things on how to address with the city that's affecting your community. So you're more than welcome to come on out from 6 to 8 p.m. again at the Hiram Clark Multi-Service Center. And then also, if you are wanting to be more civically engaged in your community, or if you already are civically engaged and want just some tools and tricks and education to improve your civic engagement journey in life. The Neighborhood Academy, formerly known as Complete Communities University, is now Neighborhood Academy. We are in the application process, so we're still accepting applications up until this August 30th. So please visit our website, Department of Neighborhoods, to apply if you're interested. We have also coffee and conversation on next Tuesday with City of Houston again, Department of Neighborhoods, where we'll be going over some things that there to help residents. We'll be at the Kashmir Multi-Service Center from 10 to 12. So again, you're more than welcome to join us there. And I think, and then our last, we are having an in-person workshop this month. On the 28th at the Sunnyside Multi-Service Center. So you see, we're getting out there in the community. We're going, from district to district, but we'll be at the Sunnyside Multi-Service Center At 1 p.m., we're going to be discussing our property taxes exemptions and payment options. So if you have questions about that or wanting to be more educated or informed, you're more than welcome to join our workshop on next Wednesday in person at Sunnyside.
And that one will also be hybrid. So for those
Yeah.
folks that so it's not only just in person, but if you are in the area and you want to kind of come back out, or if you're not technologically savvy or what have you, and you know people in your neighborhood that has questions about their property taxes or want more information about exemptions, that would be the perfect time to have them come out and re-engage with folks with the county so that they can have those questions addressed. Tomorrow's presentation will be the maintaining and adding value to your home, basic home maintenance things. And let's see, foreclosure prevention, HOA foreclosure will be on Thursday, also presented by Lone Star Legal Aid from 1 to 3. And I'll include this schedule of everything else that we've got coming up for the month of August into the email that I send out to you guys with the email with the link of this presentation that was presented here today, in case you want to go back and make reference or share it with somebody else that may also find the information to be beneficial. So with that being said, thank y'all very much.
Hey, Rachel, if I may, Rachel, if you ever want to do a coffee and conversation with some judges around the civil process, especially when it affects our seniors, because we do deal with a lot of issues concerning civil procedures when it's concerning our seniors, to get the knowledge, just let me know. Even though I know we're a county, but it affects the residents of the city of Houston. So in precinct 7, just let me know. I'd be honored to do that. It'd be good to get my work back to my former stomping ground.
Absolutely, Judge Adams. We're more than welcome to have you do that. And obviously, there's a big community that we
I
that
think
we.
I have it on my schedule to come tomorrow night. I think I said I was going to come by. When I saw it, it was at Higham Park, not too far from where I live.
Yes, ma'am. Well, I'll see you there.
Thank you, Miss Nia.
All right, thank you. You all have a wonderful remainder of your afternoon. Take care of yourselves, stay safe, and we will see you all next time. And thank you for tuning in.
Bye, everyone.